Hi everyone, it's Kelly Longtin from Kelly Longtin Law, and today I want to talk to you about what happens if your beneficiary passes away before you do when you've set up a will or a trust. Now, when planning for death, most people assume they'll die before their beneficiaries, their spouse or their children or their grandchildren, and while these assumptions are often pretty well founded, they do not always come to pass. Sometimes a beneficiary of an estate or a trust dies before the person leaving the inheritance. And if this has happened to you, you may be wondering, what is next? How does this event impact your original plans? Now, the truth is, it depends on a number of factors. Now, we as lawyers call this scenario having a predeceased beneficiary. Now, if you have a predeceased beneficiary, you must review your estate planning to see what accommodations, if any, exist for this scenario. The review of and any updates to your estate planning documents are critical to ensuring your valuable possessions are distributed the way that you want them to be. The details of your plan should outline the various accounts in the property that you own and how they are to be treated in the case of a predeceased beneficiary. Now, parsing through your accounts and property is key for navigating this situation. Failure to address a predeceased beneficiary in your plan could result in the state deciding the fate of your accounts and property, which may not serve your purposes and can ultimately leave your remaining beneficiaries sorting through what's going to be a legal nightmare. The most common scenarios regarding predeceased beneficiaries are that, one, your estate planning documents are silent on the issue, or your estate planning documents do not name contingent beneficiaries at all, or the ones that have been listed have passed away, or your other assets don't list contingent beneficiaries or even primary beneficiaries for that fact. An estate planning document is silent on the issue of predeceased beneficiaries if no contingent beneficiaries are identified. A contingent beneficiary is a backup, a secondary beneficiary who receives an account or a piece of property if the first beneficiary, which we call the primary beneficiary, dies before you do. Now, if no contingent beneficiaries are named, the gift in question is canceled, and the accounts and property will be considered part of your general estate and distributed according to the will, or if you don't have a will, according to the state law, through a process called probate. Now, in other words, the beneficiary's portion is absorbed back into the estate and becomes part of the leftover of the residuary of whatever is left. This cancellation can be problematic if the beneficiary has descendants who you would want to receive that portion of the inheritance if their parent or whatnot had passed away. So, for example, Adam had a daughter named Becky, and Becky has 3 children. Now, Adam's will states that Becky will inherit his prized antique collections. Now, if Becky dies before Adam, and if her children are not named as contingent beneficiaries, specifically named, then this could result in her children missing out on this gift of the antique collectibles. Now, that is definitely not something that Adam would have wanted, and it's not what most people want. It's just often overlooked when it comes to estate planning and a predeceased beneficiary. Now, if your will or trust specifically names a contingent beneficiary, the result is fairly straightforward. The individual identified will inherit the beneficiary's portion. However, if a specific name has not been identified, the assets may be distributed a few different ways depending on what stipulations, if any, were made in the original estate plan or what the default provisions of the applicable state law are. Now, the first common way in which it's listed in estate plans is what we call per stirpes. And in some cases where the will or the trust has not specifically identified to whom a specific asset should go, the distribution may be made per stirpes. A per stirpes distribution just means that the next generation of the beneficiary receives that beneficiary's share in equal amounts. Now, one potential downside to this approach is that the spouse of the beneficiary may be completely left out of the distribution. Now, the other type of distribution that you see is what's called per capita. It's called per capita with representation. In other instances, a per capita distribution occurs because it wasn't listed and according to state law. Now, this type of distribution provides another option that leads to equity at each generational level. So essentially, the assets are divided by the number of heirs in the generation level. In other words, a predeceased beneficiary's children will receive the same portion as their cousins if their parents are also predeceased. Now, the language of your estate planning document should dictate how beneficiaries and their shares are to be treated. In most instances, it's prudent to revise your estate planning documents so that they accurately reflect your current wishes. Now, having an up-to-date estate plan document or documents helps to ensure that your wishes are clearly communicated to the people that will be involved in administering your estate. This saving time and money and stress for your loved ones during what is an extremely difficult time. Now, it's critical to ensure that your planning is flexible enough to accommodate for the many changes that occur in life and death. And if you need help reviewing your documents to make sure that your goals will be carried out as you would expect, then just call and schedule an appointment with me. I'll be happy to help you plan for the various life events that come your way. I'm Kelly Longtin from Kelly Longtin Law.